Welcome to IRiQ Talking IR, and really pleased to introduce the latest addition to Team IRiQ, Terrianne Redman. Welcome to IRiQ Talking IR. So today we're going to be discussing the inquiry that's currently underway into the operation and adequacy of the National Employment Standards. Now that's being undertaken by the Standing Committee on Employment, Workplace Relations, Skills and Training, and arises from a commitment that was made in the 2022 Jobs and Skills Summit. We all know, or we might recall, the Jobs and Skills Summit. There was a lot of chit-chat, a lot of talk. This was one of the things that came out of it. Now we've already seen quite a lot of reform that was alluded to, discussed, foreshadowed, quite possibly a fait accompli at this Jobs and Skills Summit. And so now we're moving into a really close look at the NES. Jo, do you want to just talk us through the terms of reference and what this is really about?
Yes. So it's interesting having a look at the TOR, and as you mentioned, Rebecca, it's based on the NES, its operation and its continued adequacy for providing minimum entitlements. So the TOR includes looking at the objective and the purpose of the NES. So is it the safety net that it needs to be for individual entitlements? Is it fit for purpose? Does it need to change? Does it meet the objectives of the Fair Work Act? How is it in operation? Does it need improvements to make it more effective? Its interaction with other workplace instruments, so modern awards, enterprise agreements, individual flexibility agreements as well. Does it consider the type of workforce that it needs to, given the different demographics that apply? So for example, women, workers over 55, younger workers, First Nation workers, workers with a disability, and what gaps might actually exist. So it's a very broad TOR, and it's really designed to look at all aspects of the NES with the exclusion of a couple of elements, which is requests for flexible work arrangements, casual employments, parental leave and family and domestic violence leave. They have already been addressed in earlier variations that we've seen through legislation.
And I suppose before we get too far into the discussion, as you alluded to and mentioned, the National Employment Standards are a safety net of entitlements, and they deal with fundamentals such as entitlements to leave, entitlements to notification in the event of termination, entitlements to redundancy, and many other things. And they have been expanded over the years in terms of additions that have been made to them. And that didn't require an inquiry like this. So in some respects, one of the anticipated outcomes is the potential for some significant change to how we've always dealt with the National Employment Standards. But one of the critical features of the NES has always been that it can't be contracted out of or reduced in an industrial instrument such as an enterprise agreement. So in terms of the often utilised sort of triangle of employment rights and entitlements, it sits at the top. So it's a pretty significant piece, and the notion that there's going to be significant change has clearly garnered a lot of interest when we come to talk about the individual submissions in particular. Just on that point, Terrianne, are there any observations you've made about the submissions that have been published today?
Yes, I was surprised to see that some of the bigger players haven't put submissions in at this point, although I do note that it is still up until tomorrow. You know, the submissions can be submitted till tomorrow. But there's quite a lot of individuals who've made submissions to date that you probably wouldn't normally expect to see in such an inquiry. You know, there are some of the larger players in the industry, but you know, the likes of ACCI and ACTU and so forth have not as yet put anything in, and you would expect to see that given, I guess, the breadth of the terms of reference and, you know, the application of that to such a critical, you know, industrial set of terms, you know, for Australians. So I would expect to see those coming through fairly soon.
How many submissions are there to date?
There's 21 according to the website. So, as I said, most of those appear to be individual submissions, and there are some from, you know, Electrical Trades Union, the National Farmers Federation, and HIA. One of the chambers in WA has submitted to date, but haven't seen anything that you would expect of such an inquiry, and certainly, you know, haven't seen necessarily the, you know, a lot about it in the media or anything like that I would have thought at this stage.
Yeah, which is really interesting, because when we've had inquiries like this in the past, particularly before we saw the 3 tranches of reforms, the media was very active in talking about the inquiries, in talking about the proposed changes. So it could be that this is really just to get a sense that the government hasn't yet determined what they want to do, but it could be the other way around. And as you said, Terrianne, there could be a flurry of the usual suspects, ACCI, ACTU. We haven't even seen anything from Professor Andrew Stewart. So I think tomorrow, closed business could be quite interesting. Could be that we see a few more come in next week, who knows? Yeah.
Yeah, and we'll actually come to discuss with you, Jo, some of the industry bodies and unions that have to date made submissions and what they're talking about. But what I found quite interesting is the nature of some of the individual submissions. And we'll go through some of those now. Some individuals have nominated to be de-identified, which is fine, that's their entitlement. Others haven't. I think what's interesting is the call for additional leave. So employees are saying 20 days isn't enough, and some of the submissions dealing with a call for an extra 5 days per annum of leave, paid annual leave, are talking about the continuous nature of some of the industries that they work in, particularly in retail. So the SDA hasn't yet, well, the SDA submission isn't published yet, but one of the individual submissions refers to their support for the SDA's proposal to increase the minimum paid annual leave from 20 days to 25. And the rationale around that is that employees, particularly in the retail and fast food industry, are more productive, more connected and under greater pressure than when the NES was introduced. Working longer hours, digital availability, customer-facing stress and irregular rosters are normalised across their particular industry, retail, fast food and distribution. And so the response to that is a call for extra paid leave to address potential burnout and mental health concerns there. It's interesting to me that this is, in some respects, approaching the NES as a means to cure all. And that's not really what it's for. So to the extent that, for example, things like rostering are problematic in the views of some employees, there are other ways to deal with that under the terms of modern awards that have rostering provisions, for example. But that's the submission, at least, for retail and fast food workers. One of the other submissions I thought was particularly interesting because it was typed, and it does appear to be typewriter typed, not just computer typed. 100% gold for that effort. This submission is calling for the NES to deal with the ability to cash out long service leave. I'm not sure whether that is simply misunderstanding the state-based provisions that already deal with the ability to cash out long service leave in certain circumstances. But in some ways, it's not surprising for individuals to want to see some harmonisation about things like long service leave and portable long service leave in the nest, because it seems like a logical place to put it. And as practitioners in IR, we often assist clients who are in multiple jurisdictions, and it is a particular, it is an administrative burden and adds complexity that on the face of it's unnecessary, when in each jurisdiction they have to be across a different long service leave set of rules, and in those industries with portable long service leave, a different set of rules, and some of those are actually quite disparate in terms of how they deal with things like everything from coverage to the other things like cashing out.
And
so that's been tabled.
Yeah, if I could add about long service leave, back when the NES was first being drafted and developed, there was an intention for long service leave to be a standard condition. However, as part of that discussion and deliberation, it was identified that different states and territories have different entitlements. So in New South Wales, the entitlement to long service leave or pro rata long service leave will differ to Queensland. So it definitely is an issue for those businesses that operate across states. But how would you justify setting a long service leave entitlement that might be more beneficial than what we have in Queensland and more detrimental from an employee perspective to what's in place in New South Wales by changing it? And I believe that was the rationale for not actually having a detailed entitlement in the NES, and that's why it refers back to state and territories. So that's going to be particularly interesting to see how they address that, if there are commentary coming through about long service leave. And I've seen a submission as well that's also talked about long service leave should be a very clearly stated entitlement in the NES as well.
Look, I think it would be more convenient, but it would mean having to engage with the states, and I'm not sure whether that's something that the inquiry has an appetite for, but it remains to be seen. Not all of the submissions are as sort of earth-shattering. One would like to see miscarriage or a diagnosis of infertility to be added to the grounds on which you might exercise the right to take compassionate leave. And the only other one that I thought was particularly interesting, worth discussing, is a request to change the approach to personal and carers leave, to create separate essentially buckets of leave for one for personal leave and one for carers leave. So the submission here is by an individual who's not identified, but speaks from the perspective of a woman with carer responsibilities, and expresses the view that women are disproportionately impacted by carer responsibilities such that their ability to utilise personal leave for when they are sick is inevitably eroded because it's used for carers' leave responsibilities. And so having two buckets in this submission would address that inequality without necessarily, that's it, just address that inequality. It's quite interesting. It doesn't deal with what it should be, but what it does is some examples of effective carers leave in other jurisdictions like Japan, Sweden and Norway. But the other thing that I think plays into carers leave, which isn't dealt with in this submission but I think comes up often enough, is the carer responsibility for older people and older ageing parents. So, and look, whether that's creates gender-based inequality is hard to say, but that's another potential reason to say there should be two buckets, because we're not just caring for children, we might be caring for adults. So that's just a flavour of some of the individual submissions. Lots of emphasis on the right to not go to work more often. So clearly employers need to be heard on those things. Not seeing individual employer submissions just yet. haven't, as you said, Jo, seen some of the big industry body submissions we'd expect to see. Just talk us through what we have seen so far.
Yeah, well, I'll start with a couple of the specific industry groups. So the Housing Industry Association, HIA, their submission calls for a couple of amendments, considerations, so addressing the residential building industry and specific requirements out of that, and somewhat not surprisingly, which we might see with a number of other employer associations, small business carve-outs as well, so how that applies. The National Farmers Federation have put forward a submission. They've recognised the NES as a safety net, but they'd like to see some simplification and some technical improvements to it so it's easier for all parties to understand and to put into practice. They've talked about addressing non-traditional work arrangements where needed, so through separate tailored mechanisms being outside of the NES.
What are some examples, Jo, of those arrangements? Have they been indicated?
What they're recognising is that the traditional employment arrangements that apply, the NES is fit for purpose, but looking into some of the platform-based, the gig-based, which would be, I guess, characterised as the non-traditional, the calls for the NES to deal with those arrangements perhaps requires a lot more consideration before that actually occurs. So the Farmers Federation is recognising that we've got traditional and non-traditional, but has also made it clear that there should be fit for purpose arrangements for those types of workforces, but not necessarily within the NES. One of the things that they've recommended as well is that workers' compensation leave accrual, public holiday rostering and requests. So we discussed that in our December IRiQ Talking IR with some of the case law that's come out from that. So they're focused on reducing risk for non-compliance by keeping things simple, easy to understand and clear for all parties. So that's interesting.
It's a fabulous objective for any document, let alone the most important document for employment conditions in Australia. Excellent, thanks, Jo. Anything else you want to mention about the submissions that have come in from maybe unions?
Yeah, well, we've talked about individuals, we've talked about a couple of employers. The ETU has put forward a submission, and in short, what they're looking for are some changes, annual leave and limiting the circumstances where employers can direct employees to take annual leave, so that it still needs to, from their perspective, retain a benefit to the employee to have to take that leave. They've addressed uniqueness for their industry. FIFO is the NES fit for purpose with the leave entitlements, and they've raised the matter of portability of entitlements as well. As we've discussed, you know, in Terrianne, you mentioned people move from state to state and difference in entitlements. So that's not surprising. They're representing their membership and their employee concerns. So, I mean, the whole review is about everyone getting to have their say for their members, for their constituents, for their individual circumstances. So I think, you know, this is really interesting, talking about what different parties are seeking from the review, but the important thing is what's next. So Terrianne, what can we expect?
Well, look, the submissions close tomorrow, so I would expect to see a lot more submissions coming through from the key players particularly. And, you know, from that, we don't really have any time frames specified for when the next steps are happening. But, you know, assuming that sort of by next week we'll know what all the submissions cover and so forth, they're could potentially be some media coverage over it. Once the submissions all come through, there might be a few more contentious type of requests for looking at different aspects of the NES or inclusions that aren't there now.
That's really interesting. What do you reckon? Do we expect political parties to put submissions in? Because the NES, this is where there may be a move to enshrine 2 days per week working from home entitlements.
Well, and that's a really good question. That is possible, I think. Yeah, and I guess the other thing that will be really interesting to see is whether or not the change in the way people work, working from home since COVID, because the NES is pre-COVID. Post-COVID is a very different working world, and the type of flexibility that people are expecting nowadays is something that potentially they would expect to be enshrined in some minimum entitlements going forward. So I'd be really interested to see if we get more of that coming through.
It's a great point that you make, Terrianne, that we are in a new working world since the NES was established, and there may well be a good basis for change, and hopefully to strike that balance, because at the end of the day, the objectives of the Fair Work Act are around creating fairness for employers and employees, and improving productivity and relationships. So it needs to strike that balance, but it will be interesting to watch. What I want to ask each of you, if you had a magic wand and could change one thing about the NES for the benefit of our clients, who are more often than not employers struggling with complexity or other features that they need to navigate, what would you change and why?
Workers' compensation is something that we do get a lot of queries about, and what happens when a person's on leave. Now, I think the NES, by reference back to state and territory legislation, is clear there, but maybe it's the aspect of referring back rather than everything being in the one place that could be addressed by clear, simplified, easy to understand expectations for everything. I'm not quite sure how you do that, because that does rely on interaction, but I do see there could be some benefit for employers in having that clarity. But that's also a benefit for employees to be able to read it and say, this is what I'm entitled to.
Okay, great.
Yeah, probably I would say, the personal carers leave is something that employers don't always necessarily understand. When is it personal leave? When is it carers leave? When is it okay for someone to take, unpaid carers leave versus, well, I'm caring for a sick child. And that comes out of a bucket of paid leave if they have it. Potentially, it would be good to see some, gender equity principles built into some of that as well. I guess for employees as well. But I think it would be great if there was a bit more of a simpler approach to some of that, I think, from an employer's perspective.
I'm sensing some overarching themes here. One is simplification.
Well, I wouldn't be surprised if we see a submission saying, let's reduce the 38-hour week to a 36, because we used to have a 40-hour week, then we had 38, so...
Yeah, that's an interesting
there's an argument it's time that it moves down to 36. Recover.
Rest harder. Yeah, look, I say work
rest
hard,
harder.
work
I
hard,
like
spar
that.
harder.
That's rest harder.
That's my motto in life. So interesting.